It happened. Your relative, maybe your mom, your brother, your uncle, your spouse passed away. And now, in the middle of grief, in the middle of family chaos, in the middle of funeral planning and group texts and casseroles showing up at your front door, you're thinking, oh, they didn't have a will. We never talked about any of this. Like, wow, can we still do something now? We need to protect the house, to avoid court, to fix it. So, and maybe someone in the family or even your own gut is asking, is it too late to do estate planning after someone dies? That's today's episode because this is a question I get constantly.
Welcome to Gavels Down, Voices Up, where we flip the script on conventional legal discussions. I'm Rachel King, here to guide you through the murky waters of estate conflicts, inheritance disputes, and all of the dramas. We're not just talking about law, we're talking about how it affects your life, your rights, your future, and your money. From the courtroom to your living room, we bring you insights that matter. Dive into each episode ready to challenge, learn, and grow. Ready to change the dialogue. Let's begin. Gavels down, voices up.
Someone dies unexpectedly and the family scrambles to get legal clarity. They want to know what happens next. And they want to know if it's too late to protect what matters. So we're going to walk through it step by step, from the first phone call to the last court document. Today's question is deeply human and deeply common. My relative died yesterday. There's no will. Can we still do estate planning? Let me give you the short, honest answer. No, you can't do estate planning after someone dies. Estate planning, by definition, requires a living person with legal capacity. It requires someone to say, this is what I want. This is who I trust. This is how I want my money, property, or care handled. Once that person passes away, the planning door closes and a new door opens. Administration, we're not planning anymore. Now we're administering. But here's the good news. While you can't create an estate plan after someone dies, there's still a process. There are still options. There's still a path forward, even without a will. That process is called probate. And yes, it's probably not what you hoped for. You might have wanted to keep things out of court. You might have wanted to avoid legal fees, delays, or family conflict. But if you didn't plan before, then probate is how we sort it out now. So what exactly is probate? Probate is the legal process for settling someone's affairs after they die, especially when they didn't leave a will or trust. It involves identifying heirs, collecting and valuing assets, paying off debts, and distributing whatever's left to the people entitled to receive it. If there is a will, the court will follow it. But if there's no will, which is what we're talking about today, then California law decides who gets what. This is called intestate succession. It's a legal formula that determines who inherits when someone dies without a will. Here's a quick overview of how it works in California. If someone dies with a spouse but no children, the spouse gets everything. If they die with children but no spouse, the children share everything. If they die with a spouse and children, it gets split. Depending on whether the assets were separate or community property. If they had no spouse or children, then we move to parents, siblings, nieces and nephews, cousins, even down to more distant relatives. The law creates a default plan, a best guess of what the average person would have wanted. But as you can imagine, it's not always what the family wants, and it often creates tension. Let me tell you about a family I worked with. I'll change names to protect privacy. Anna called me the day after her father passed away. He died suddenly, no will, no trust, no written instructions. He had 3 children, no spouse, and a home in his name only. Anna assumed that since she had taken care of him for years, she'd automatically inherit the house. But under California's intestate succession laws, all 3 siblings had equal rights. And one of them, let's just say they weren't exactly cooperative. We had to open probate, we had to notify everyone, and we had to follow the law, even though the emotional story said something else. That's why I always say, if you're listening to this episode before a death in the family, this is your sign to plan now. But if you're here because it already happened, let's talk about what you can do today. The first thing you need to know is this. Only certain people can open a probate case. Usually that's a spouse, an adult child, a parent, or another close relative. Sometimes it's a creditor. If bills are piling up and no one is stepping forward, if there's no family or if the family is fighting, the court can appoint a public administrator. The second thing to know is probate only applies to certain assets. Not everything has to go through court. Assets that typically do require probate include a home titled in the name of the deceased alone, bank accounts without a joint owner or named beneficiary, investment accounts without a transfer on death designation, and personal property over a certain value. Assets that usually don't require probate include life insurance with a named beneficiary, retirement accounts with a designated recipient, jointly owned property with right of survivorship, payable on death accounts. So, one of the first things I do with clients is review the asset list. We figure out what's going through probate and what's not. Third, we file a petition for probate in the county where the person lived or owned property. This starts the court process. We publish a legal notice in the newspaper. We send notice to all known heirs and creditors. We inventory the assets. We pay off debts, taxes, and expenses. And finally, we distribute what's left to the rightful heirs as determined by the court. It's not quick. In California, probate usually takes 12 to 18 months, sometimes longer if there are disputes, but it does provide a legal final resolution. Now, let's address a common question I get in this exact situation. Can we just transfer the house to someone's name instead of going to probate? I wish it were that easy, but the answer 99% of the time is no. You cannot transfer ownership of property titled in the deceased person's name unless you have either a court order via probate or a trust that owns the asset and names a successor trustee. No one can forge a deed, no one can add their name retroactively, and even if everyone in the family agrees, the county recorder won't transfer title without legal authority. Another question I hear, can't we just create a will now and say it was their wishes? Unfortunately, no. Wills must be signed by the person while they are alive and have capacity. Posthumous estate planning isn't legal. Trying to backdate or forge documents is fraud, and it can land you in serious trouble. So, no, you can't plan after death, but you can administer responsibly, transparently, and with the help of the right legal tools. Let me tell you about another case. Michael called me 2 days after his aunt passed away. She had no children, no spouse, no will, just a house and a savings account. Michael had been her caregiver, and everyone in the family agreed he should inherit. But without a will or trust, we had to follow the intestate rules. We identified other heirs, 2 distant cousins, and brought them into the case. Michael ended up with a majority of the estate, but it required court approval, waivers, and time. The lesson, even if the family agrees, you still need court involvement when there's no estate plan. Now, let's talk about what you can do in the days and weeks after a death, even without a will. Step 1, secure the property, change the locks if necessary, prevent unauthorized access, make sure the home, valuables, and documents are safe. Step 2, order the death certificate. You'll need certified copies to open probate, access accounts, and deal with agencies. Step 3, identify assets and debts. Start a spreadsheet, list every account, policy, property, or bill you know of. Even if you don't have account numbers, start building the picture. Step 4, consult a probate attorney. This is where we come in. We help you determine whether probate is necessary, who can file, what forms are needed, and what strategy is best. Step 5, gather contact information for heirs, beneficiaries, and relatives. You'll need this for notice requirements and court filings. Step 6, stop automatic payments and subscriptions, notify banks, prevent identity theft, pause financial activity until someone is legally appointed to act. And step 7, the one most people skip, take care of yourself. You are grieving, you are overwhelmed, you are stepping into responsibility that was never meant to fall on your shoulders alone. So ask for help, rest, breathe. You're not expected to know how to do this. That's why people like me exist. Let's close with this. If your loved one passed away without a will, no, you can't go back in time and create an estate plan, but you can move forward with honor, clarity, and legal authority. You can do what needs to be done. You can settle the estate legally. You can avoid disputes and future confusion. You can protect your own family by learning from this moment and choosing to plan ahead. Because every probate I handle, it teaches me something. It reminds me that no one expects to die suddenly, that paperwork is love, that clarity is protection, and that every family deserves to be empowered. Thank you for listening to this episode of Gavels Down, Voices Up. If you found this helpful, share it with someone who just lost a loved one. Let them know they're not alone. And if you're ready to understand your next steps, visit thelawyerking.com. I'm Rachel King. I'm reminding you, you can't plan an estate after someone dies, but you can still lead with clarity and courage.
That wraps up another episode of Gavels Down, Voices Up. If you found value in our discussion today, please subscribe, leave a review, and share with someone who needs these insights. Your engagement helps us grow and impact more lives. I'm Rachel King, thanking you for listening and reminding you to speak up because every voice deserves to be heard.